I'm Laura Begley, and you've got Kerry Nicholson on the line as well, and we're here to talk to you about expert evidence. So just by way of preliminary comments in terms of housekeeping, you'll find at the bottom of your page, if you run your cursor down, there's a Q&A box there. So if you have any questions as we go along, please do pop them in there. We won't deal with them until we get to the end of the talk. But we will deal with them, and the slides will be emailed to you as a PDF after the talk. We think the talk is going to take about an hour, and we'll chivvy each other along if we look like we're taking any longer than that. So Kerry's going to start with an introduction to the basics and some specific examples in terms of expert evidence, and then looking at guidance on instructing experts, their duties and responsibilities, and what happens when it goes wrong, because it does from time to time. And then I'm going to pick up and deal with joint reports, lessons learned from a case called BDW Trading, and then also what you can do if there's a change of opinion in terms of experts, so substitution of experts. So without further ado, I'm sorry about the little chat beforehand, please forgive us. But we're utterly focused now, and Kerry is going to start with the basics in terms of expert evidence.
Brilliant, thank you, Laura. So as you mentioned, I'm Kerry, and I'm going to be starting by going through some of the basics of expert evidence, and I'm really going to go back to basics. So just humour me at the start, because I'm sure I'll be teaching some of you how to suck eggs. So when can expert evidence be used? Some specific examples of when it will and won't be needed, and then things to remember when instructing your experts. So when can expert evidence be used? As you'll all be aware, generally you're not allowed opinion evidence, but there is an exception, and it's when it's an expert's opinion. So experts can give evidence to be relied on for technical issues, scientific issues, or matters of special practice and procedure, provided that those relate to specific matters in dispute in the case. So the most obvious example is expert medical evidence. In personal injury cases, you need a medical expert to give their opinion on the injury suffered and any prognosis. However, there is a really important limitation that they can only give their opinion on a matter in which they are an expert. So they're not able to provide their views on the credibility or reliability of a witness. That's not what they're allowed to do. So in terms of some specific examples, a question that can commonly arise in a personal injury or clinical negligence case is whether the claimant's life expectancy has been reduced and what it can be, or what it is if it hasn't been reduced, but for example, their earnings have been affected. So in general, you don't need statistical evidence, but the court can sometimes allow a specific life expectancy expert if it's needed. And the court set out the principles in a case called Dodds and Arif, and Master Davison distilled the authorities down into basically 4 principles. So if a person's injury hasn't impacted their life expectancy, so if it remains the same, there's no need for evidence on life expectancy unless the person is atypical. So they would naturally have a longer or shorter life expectancy. If the injury has impacted their life expectancy or they are atypical, the starting point is that the clinical experts already instructed are able to provide their opinion on life expectancy, and there's no need for a specific expert on it. The methodology in which those experts arrive in assessing the claimant's life expectancy is entirely a matter for them. And then finally, permission for bespoke evidence on life expectancy can be needed if, for example, the clinical experts can't offer an opinion on life expectancy at all, if they give reasons stating that they need some input from a life expectancy expert for whatever reason, or they agree on the statistical material but they don't agree on how to deploy it. So really they can only get the input of a life expectancy expert if they can't determine it themselves, or for some other reason they require that specific input. The court confirmed that this was the position in Chaplin and Pistol. Again, bespoke evidence should be confined to cases where the clinical experts cannot offer an opinion, where they need input, or where they can't agree on the correct approach. So some other examples on where there may be an issue relevant to the case, but it's not necessarily need an expert on those issues. So pain evidence and ergonomics. So starting with pain evidence, pain is going to be relevant in many, many personal injury claims, but a pain expert is only going to be required in quite specific circumstances. In the case of Daly and Milton Keynes Hospital, the court refused permission to rely on a pain management expert because it was not clear how their evidence was going to assist it in determining the issues of liability and causation. Further, that evidence was sought to help bolster the credibility of the defendant's evidence and therefore could not be permitted. As we've already touched on, expert evidence isn't to go to the witness's credibility. In the case of Team Techs, SAS and Wang, permission for an ergonomics expert was refused in respect of the clarity of instructions for fitting a car seat. So in that case, what the court had to decide was whether a person of reasonable intelligence was going to be able to follow the instructions. And it was held that there was not, an expert wasn't needed to be able to tell a judge whether or not instructions were reasonably intelligible. So the question remains, is the expert evidence reasonably necessary to determine the issues in the case? In terms of instructing experts, it's really important that both yourselves and the expert are familiar with the very catchily named Civil Justice Council's guidance for the instruction of expert in civil claims, as well as CPR 35 and its corresponding practice direction. So the key issues for you when you're going to instruct an expert, first of all, as we've already said, is their evidence reasonably necessary? And then giving them clear, complete instructions. So paragraph 20 of the Civil Justice Council guidance sets out things that should be included, instructions to experts. And it's basically a long checklist. It's even set out in bullet points like a checklist. You can just keep your eye on it, go through, make sure, yes, I've done that, because it is a long list and it can be quite easy to accidentally forget something. So that's a really handy thing to keep an eye on when putting together your instructions for your experts. In terms of things that they need to be aware of, they need to be aware that they have to respond whether or not they're going to accept instructions without delay. If they have any conflicts, if they think that they're not going to be able to meet the deadlines, for example, if they don't think that they have sufficient instructions to complete the work, and if they're not satisfied that they can comply with any other orders that the court has made, they have to keep you up to date of all of that. So now moving on to the specific duties and responsibilities that experts have. It's really, really important that both you and your experts, this is a somewhat alarming picture, but it's really, really important that everybody is aware of what's in CPR 35 and Practice Direction 35. In Practice Direction 35, some of the key takeaways are, and we've touched on these already, experts of like discipline should have access to the same material. So everybody should be singing from the same hymn sheet, regardless of who instructed them. They should have all of the same evidence before them to make their opinions. Experts are independent. And again, it's not for them to indicate which version of facts they prefer. And they shouldn't be taking a partisan stance on interim applications. And any time that they're meeting to try and agree something, they should be constructive and cooperative in line with the overriding objective. Experts are also under a duty to approach the case proportionately. It's not just parties. They have to deal with the matter proportionately in terms of costs. If material does emerge close to trial, that means that they want to reconsider their opinion, they think that some further testing is required, they need to notify any other experts as soon as they realise that, as soon as possible, to stop any delays. And it's only in really exceptional circumstances where it's completely unavoidable that an expert should produce a further report during the trial that takes the other side by surprise. Normally that shouldn't be happening, and the court won't allow it to happen. So in terms of the content of the report, Practice Direction 35 mandates the formalities. The content is going to be governed by a combination of the expert specific instructions, their obligations to the court, and then any directions that the court has given. It's really important that the report is addressed to the court and not the party that has instructed them. In terms of format and content, the Academy of Experts and the Expert Witness Institute both have model forms of reports that are really helpful in terms of complying with the various requirements, as well as presenting the report in a judge-friendly format that's going to make the expert's evidence accessible to the tribunal that it's aimed at. It's also really important that the report contains a statement that the expert understands, has complied with, and will continue to comply with all of the duties upon them, as well as a statement of truth. So in terms of scope of the expert opinion, experts need to consider all of the relevant subject matter, but their actual opinion is confined to matters that are both material to the disputes of the case and lie within the expertise. They do have to cover the whole of the relevant subject matter, and they're not allowed to only select evidence which supports the case of the party instructing them. So the case of the Icarian reefer, and probably Icarian reefer, I never quite know how to pronounce that. It's a pre-CPR case, but it set out some really helpful principles and guidance on what experts should be doing, and the courts post-CPR have confirmed that it's still good guidance. So in a nutshell, experts should be impartial. They should be providing assistance to the court, independent assistance to the court. They must never assume the role of the advocate, and we'll circle back to that a little later and what can happen if they stray into acting as an advocate. They must state all the facts and assumptions which they've based their opinions on. They need to make it really clear if a particular issue falls outside their expertise. And they also need to make it clear if there's insufficient data to allow them to come to a conclusion. If they have any qualification about the completeness, truthfulness, accuracy of their report, they need to make that really, really clear as well. And if something comes to light that changes their opinion, again, they really can't delay in communicating that to everybody involved. And finally, if the report refers to photographs, surveys, other documents, those documents need to be provided to the other party at the same time that they're served with the report. So there are a couple of cautionary tales now about how even very experienced experts can find themselves falling foul of the requirement to be independent and the potential consequences of that. So William and Jarvis, the defendant's neurosurgery expert, made mistakes that caused the court to find that his evidence couldn't be relied upon. So his report came to conclusions about the claimant such that she was a sophisticated claimant whose history was littered with inconsistencies and whose account was not to be relied upon. And it seems that Dr. Gross, the expert, had formed a view of the claimant, and this had impacted his impartiality and objectivity when conducting his role as an expert witness. Problems that the court identified with were that his report had included significant inaccuracies between what the claimant had told him during her examination and what had actually been recorded in his report. And that only came to light because the claimant had actually audio recorded the examination and provided a transcript of it to show that really what she'd said and what he said she said were really quite different. During cross-examination, he refused to accept those obvious mistakes. He had come to conclusions about the claimant's physical condition when it came to light that he hadn't actually done the required physical examination to come to those conclusions. And then in the slightly more cloak and dagger side of things, he obtained evidence about the case other than from his instructing solicitor. There was an unmarked brown envelope. He said he'd received a report that he didn't know what it was. And it turned out that one of his colleagues had previously been instructed by the claimant and had produced a report that was not relied upon or disclosed. And he asked for and got a copy of that report, and then said that a week before a trial he'd received it anonymously and didn't know what it was. The court rejected that explanation and found that he had actually misled his solicitors. In another very misjudged move, he also contacted a potential witness that he considered could help support the defendant's case and encouraged them to give evidence. So looking at all that in the round, the court found that he hadn't acted objectively and had crossed the line into advocating for the defendant. And in that extract from the judgment we can see there, it says, "It is equally likely in my judgment that he approached the case with a set view of the claimant and looked at the claimant and her claimed symptomology through the prism of his own disbelief. From that unsatisfactory standpoint, he unfortunately lost the focus of a expert witness and sought to argue a case. I am driven to the conclusion that I'm unable to place reliance on Dr. Gross's evidence in this case." And it's very easy to stray into that, and it's so important that experts keep at the forefront of their mind all the time what their role actually is in giving expert evidence. Similarly, in Ruffle and Lovett, there was a pain expert that the court again found itself unable to rely upon. It found that Dr. Jenner was dismissive of those who did not agree with his rigidly held opinion, and the court found that that was inconsistent with the obligation of an expert to consider and acknowledge where there is a range of opinions, even if the expert for his own reasons rejects them. It also found that his evidence was combative and that he repeatedly tried to act as the claimant's advocate. The court held that there was a lack of balance and much argument in his evidence. Rather than answer a question directly, Dr. Jenner would often sidestep and respond with an argument to support the claimant's position. And again, this resulted in the court rejecting his evidence because he wasn't acting independently and impartially as he should. That duty to be independent also extends into covering the substance of all material instructions. Basically, there's no such thing as an off-the-record instruction, and everything they've been instructed to do must be noted down. They can't leave things off book, as it were. So what does happen when experts fail in their duties? Well, other than, for example, their evidence not being relied upon, there can be cost sanctions, and that includes on the experts themselves. So the guidance there, experts should be aware that any failure to comply with the rules or court order or any excessive delay for which they are responsible may result in the parties who instructed them being penalised in costs or debarred from relying on the expert evidence. In the case of Themaya and Lancashire NHS Trust and Mr. Jamil, the expert was subjected to almost £90,000 in wasted costs, and the claimant had to discontinue her claim. And the court said that the question is whether or not in that claim at the relevant time, the expert had a proper understanding of the test to be applied in giving an opinion as to whether a clinician had been negligent. And plainly, by the time of trial, he did not. So he wasn't able to address the most basic questions upon him. The case had continued and wasted a lot of court time and the defendant's time, and the court found itself in no other position but to order wasted costs against him. So some final checks. You've instructed your expert, you've got their draft report. Before filing and serving it, it's really important to check that everything that the expert has relied on are all the final served versions of witness statements and other reports. And if you do want to ask for an amendment of an expert report, you need to be really clear that you shouldn't be asking them to amend, expand, or alter in a way that distorts their opinion. But if you think there are some parts that they haven't expressed themselves clearly, you don't understand fully, there's some inaccuracy in the way that they've recorded the facts, or there's some internal inconsistencies, you can ask for those amendments, but it's important that that doesn't stray into trying to get them to distort their opinion as given. And now that's enough of the basics. I'm going to hand over to Laura to talk a bit about joint reports.
Okay, so we're going to have a look at the purpose of joint reports, agendas, BDW trading, and then what happens, or what steps you can possibly, in the circumstances under which you may be able to change experts. Next slide, please. So the purpose of joint reports is set out in 3512. So where possible, to reach an agreed opinion and to identify what is not agreed, and any action to resolve any of the outstanding issues. Now, you, like me, may have had conferences from time to time with experts who've passed comments that make you think, do they think it's their job to actually compromise the claim? And you can understand that because CPR's 3512 says where possible to reach an agreed opinion, you can understand why, if they haven't understood their duties properly, they might think that it is in fact their job to compromise the claim, when of course it's not. It is their job to identify and discuss the expert issues in the proceedings, and then where possible to reach an agreement on those, or to reach an opinion, agreed opinion on those issues. So they're not to seek to settle the proceedings, and it's very important that they understand that. I think we all know that lawyers don't attend, although Lady Justice Hale, I think in the case of H against Lambeth and Southwark and Lewisham Health Authority, said that theoretically you could have a legal chair, but that is something that is not commonly done. Next slide, thank you. I suspect you all know about this as well, and it's something we strive to do, which is to cooperate on drafting agendas. Next slide. So the purpose of the agenda is to indicate what has been agreed and summarise concisely the matters in dispute. Concise is a word which is relevant there, and is not always at the top of one's mind. I think sometimes when there's spats over agendas. The basic rule is avoid separate agendas. In the case of Welsh and Walsall, it was suggested by one of the parties that the form of model order, and I'm talking about the model order in clinical negligence cases, encourages more than one agenda to be sent to the experts. Amanda Yip was very clear that that wasn't the position. And she said, the standard direction makes it clear that solicitors are required to do their best to agree a single agenda. In the vast majority of cases, any disagreement ought to be capable of resolution through a bit of give and take. It may be appropriate to insert some additional questions into the draft of the defendant's request, and it certainly should not become routine to provide two versions which, as here, travel over much of the same ground. She did also say in that judgment, if the worrying trend continues, that was of double agendas or people having to go to court to try and resolve these issues, parties may begin to find that the courts consider cost consequences. So if you need to tag on a couple of questions at the end, but try and be, responsible and reasonable about what you're trying to achieve, really, because at the end of the day, whether you're for the claimant or defending, you want the joint report to be a useful, concise summary that explains to the judge at the outset of the case what is agreed, what isn't agreed, and what the reasons for that disagreement are. Next slide, please. No messing around. I love this picture. So let's move on. So the reason why I've got that slide is because of this particular case called Mayor and CMS Cameron McKenna. And in that case, the court made it very clear that experts must not be instructed to avoid reaching agreements. So that exactly the converse of what we said their temptation might be before, which was to settle the case. What you can't do and ought never to do, and I'm sure none of you ever do, is to say to them, oh, don't agree anything yet because, some further evidence may come to light, or we're trying to buy more time for settlement, or for whatever reason. You are not to do that, and they are not to accept such instructions. And what happened in Mayor and CMS Cameron McKenna was a very complex case about professional misconduct, £65 million in damages in issue, and there were two particularly complex issues in that case, and the claimant's expert on both of those issues effectively attended the joint meeting and then obfuscated and said, oh, well, I haven't quite finalized my thinking on that issue, so I can't tell you precisely what my opinion is on that. And said, well, I'll let you know my final opinion after the deadline for the joint reports, and then sought to introduce effectively an addendum or a supplemental report at that date, and then did exactly the same on the second issue because the other side had a different expert on that issue. And the court was very upset about this, as the defendants were, as you might understand, and it was described in court as a stunt by the claimant's experts. And the court said, in a nutshell, well, you can't do that. It's absolutely unacceptable. I'm going to decline permission. You're not going to be able to rely on your expert if you carry on in that way. In the end, the claimants did persuade the court to grant conditional permission. And effectively what happened was that the addendum report went in and then the defence expert had the final say. But it's a pretty clear case on what the consequences might be. And it also made the point that if your expert has engaged in any conduct like that, then you will need to make an application for relief from sanctions, or that's what ought to be done if you want to avoid having the permission withdrawn. The next slide, please. So we move on to BDW Trading. And this was a case that concerned, it was effectively a case where there was no contractual relationship between the parties. And it was all about properties containing asbestos and what information had been given by a firm of consulting engineers to a house building company. And there were 4 expert witnesses, including an expert called Dr. Tonks, who was a consulting engineer. He was a specialist in geotechnical engineering. And this was a case that appeared before the TCC. And in fact, the TCC guide, so the Technical Construction Court guide, is very similar to the King's Bench guide in terms of the guidance to parties. So the guide said, whilst the parties' legal advisors may assist in identifying issues which the statement should address, when we're talking about a joint statement, those legal advisors must not be involved in either negotiating or drafting the expert's joint statement. Legal advisors should only invite experts to consider amending any draft report, joint statements in exceptional circumstances where there are serious concerns that the court may misunderstand or be misled by the terms of that joint statement. Any such concerns should be raised with all experts involved in the joint statement. So that's the backdrop against which, so to speak. So next slide, please. And you've got the practice direction 35.9. The role of the legal representatives in expert discussions is limited to agreeing the agenda. They must not intervene and may only ask questions or advise on the law. So the point is, once you've sent the instructions to the experts to do the joint reports, it's hands off from your perspective. They've got to get on with it. They should know what their duties and their roles are. And if they do send you a draft, then you can only intervene on questions of law, or if there's some huge factual error that they've both been labouring under. So I think you're probably also all aware that experts don't require the authorities of parties to sign the statement of truth at the end of a joint report. So next slide, please. So in the BDW case, what happened was Dr. Tonks had drafted a joint report, and he'd sent that joint report to the draft to the defendant solicitors for their comments, expressly for their comments. And he got some feedback from them, and he made some changes to the draft. Now, it became apparent that he was completely unaware that that was inappropriate. So he hadn't read Part 35 or the guidance to experts, and the court held that it was a serious transgression by him. And I should say that the court also found that he had not substantially modified his opinion. What he'd done was the defence solicitors had made some suggestions, and he added some further material. So he hadn't substantially modified his opinion, but after the discussion, he'd made some additions to the report in relation to whether or not the defendant's investigation had been, and it was an issue in the case, whether that had been the main investigation in the case. And the judge considered that he had not crossed the line into inappropriate advocacy or partisan evidence, which you've just heard about from Kerry, some examples of earlier. So even though he hadn't transgressed that badly, what he'd done was still a transgression of the rules, and his conduct was judged to be inappropriate. So let's move on. So the correct approach is that the expert can provide a copy of the draft statement. They should not, and they ought not, to ask for general comments or suggestions. And you shouldn't make any comments or suggestions, save to both experts in circumstances where there are serious concerns that the court may misunderstand or be misled by the terms of the joint statement. So, for example, if when you see it, you think, gosh, they've both misunderstood some central part of the factual matrix, which seems quite unlikely, but possible, or perhaps they're going over, there may have been a concession in the pleaded cases on one particular fact, and that happens sometimes. And if you don't have a preamble in your agenda, sometimes the experts will go over issues that in fact have been resolved between the parties by some form of admission, and that can be unhelpful. So there may be circumstances where it is appropriate, but those circumstances will be few and far between. Next slide, please. So if you do need to do it, you do it in the open, so to both experts, so that everyone, including the trial judge, if the case proceeds to trial, can see what has happened, and, if appropriate, firmly discourage any attempt by a party dissatisfied with the content of the joint statement to seek to reopen the discussion by these means. Okay, thank you. So the importance of being transparent there. And now we're going to move on to experts changing their opinions and what you can do about it and when you can do something about it. So first principles are really set out in the case of Cosgrove and Pattinson. That was a boundary dispute, but there was actually quite a lot of money at stake. And there was a single joint expert in that case. I can't remember now whether it was the claimant or the defendant, but one of the parties was dissatisfied with the joint report, and in fact obtained their own report that sought to set out a basis upon which they said the single joint expert that their opinion was mistaken or erroneous in some way. And the court set out those principles from 1 to 9 there, which are, none of them will be a great surprise to you. The nature of the issues, the number of issues between the parties, the reason the new expert is wanted, the amount or the nature of the issues at stake and their importance, the effect of permission on conduct of the trial, that's quite an important one. Delay, if any, in making an application, also quite important procedurally. Delay occasioned by the new expert coming to the case, any other special features of the case, and the overall justice and merits of the case. So those are your basic principles. Next slide, please. We all remember, well, I do because I'm that old, but the case of Beck and MOD that says no expert shopping. So you can't go shopping for experts. But let's have a look at circumstances where expert substitution may be appropriate. So the fact of a change of opinion between the initial report that you've served and the outcome of the joint report, so your expert's opinion in a joint report, is insufficient to obtain alternative evidence. But where there is good reason to suppose that the applicant's first expert has agreed with the expert instructed by the other side, or has modified his opinion for reasons which cannot properly or fairly support his revised opinion, such as those mentioned in the White Book, and we'll look at that in a minute, permission may be granted. Okay, so that's your hook, that's your test. Then the note from the White Book at the time of Smallwood and David said, in practice, it could be very difficult for a party dissatisfied with an agreement reached at an expert's discussion to persuade the court that this agreement should in effect be set aside, unless the party's expert had clearly stepped outside his expertise or brief, or otherwise had shown himself to be incompetent. So the bar is actually quite high when you think about it. Next slide. So I'm going to give you a couple of examples to show the bar really in practice. So the first of which is, it's quite old now, goes back to 2012. And this was a case in which the claimant had a knee replacement, and having had his knee replacement, he went back to bus driving. And when he went back to bus driving, his knee really hurt. And he said, my knee's really hurting because of the clutch on the bus. And that is what is causing my knee to be problematic and painful. And the claimant's expert in his first report was a little bit equivocal about whether the bus driving and the gear changing would have caused the problems complained of by the claimant. So it wasn't the strongest expert report. And at the time of the joint report, the expert then said, actually, do you know what? Any competently performed knee replacement should have produced a knee that could cope with changing gears on a bus. So I'm not going to support causation. So the claimant obtained a second orthopedic report, and the district judge declined permission for the second orthopaedic report, said it was an old claim, there's lots of delay here, more costs would be incurred. It was a case which had not been prosecuted particularly quickly, and the trial had been adjourned twice already. And the original opinion had been tentative, so it wasn't a huge shift of opinion. Interestingly, the circuit judge in that case disagreed with the DJ and said, well, hang on, that shift is fatal to the claimant's case, so I'm going to allow the second expert. And the Court of Appeal said it is part of justice that unfounded claims should fail just as much as meritorious claims should succeed. And so the claimant was not successful, and the fact that this shift in opinion was fatal to the claimant's case was not determinative of the application. So next slide. And the next case is a more recent one of unsuccessful application, case of Fernandez. And in that particular case, the claimant had been engaged in some lifting and bending, sort of stacking things in a warehouse or a supermarket. And he had diabetic retinopathy. And he said that the nature of the system of work and the weights that he was lifting had caused him to suffer a subretinal bleed. He was already blind in one eye, so very sadly he became completely blind. And the claimant's expert had, a little bit like the other case, his original opinion had been just borderline in supporting the claimant's case on causation. And once he'd seen some further material, which included the fact that the claimant had been able to drive home from work after his eyesight had become challenging, if I could say that, and also had seen the defence expert, he'd changed his opinion. And there'd been 3 lots of letters to the expert to say, well, testing why he changed his opinion, and he'd answered all of these. And in those circumstances, even though the claimant had a second expert who'd effectively said, well, against his medical background, this is something that could have happened spontaneously at some stage in the near future, but probably this second expert would support causation. In those circumstances, the court declined the application and the appeal against the declining of the second expert. And so the claimant was left having to discontinue his case. So next slide, please. Oh, sorry, I should have said that it was Judge Cotter who said, clearly there were sound foundations. This is for the first expert's view, for his altered view. He'd given very careful thought to his changed position. That is one of the key things, I think. If you are going to try and substitute your expert, you need to be able to demonstrate that the first expert has gone off-piste in some way and that there isn't a good reason for their change of opinion. And I think it's also interesting to note that in this case, the claimant attempted to rely on the Court of Appeal decision in Edwards Tubb against J.D. Wetherspoon, which is a case you all may remember as well. And what Lord Justice Hughes had said in that case is there may be perfectly good reasons for a party to wish to instruct a second expert. The reasons may not always be that the report is disappointingly favourable to the other side. It will often, perhaps normally, be proper to allow a party the option at his own expense of seeing an opinion. It's not usually right to simply deny him permission to rely on expert B and force him to rely on expert A, in whom he has, for whatever reason, lost confidence. So when you read that dicta from that case, you think, well, hang on a minute, that's a much more relaxed test than the test we've just been looking at. And what the court said is, well, that's because that case concerned the terms upon which substitution could be granted, rather than on whether substitution should be granted. So that's also worth bearing in mind. And so next slide, please. So just before we leave that topic and come to the conclusions, I think one of the important things to note is whether your expert, if they've changed their opinion, what further material evidence they've had. I would always check their CVs and the CVs of the other side's expert, because sometimes it happens that one of them has been tutored, lectured, or, you know, was the registrar of the other one, and there may be some undue influence to bear, which doesn't bode well for trial if that is the position, but there might be extraneous material or other material that helps you to make the argument. I have been successful in one particular case where there was a pattern of that particular expert folding at the joint statement phase in 3 other cases with no apparently good explanation. And once we were able to produce witness evidence to that effect from the solicitor that had been involved, or knew of other people in their firm who'd been involved in those cases with the same expert, in fact, we did get permission to change horses, so to speak. So, conclusions on expert evidence. Read the guidance from the Civil Justice Council, both lawyers and experts to do that. Make sure your experts have read and digested it. Commonly, you'll be dealing with experts who are well used to it, completely understand, are well versed in these things. Sometimes you have experts in different disciplines. I'm doing a case at the moment with a motocross expert who was new to giving expert evidence, and it was very important that they dealt with the practice direction and read the guidance notes and really understood what was expected of them. The ideal opportunity for the debating, toing and froing and distillation of expert opinion is obviously pre-service. We don't always have that luxury. Litigation is not like that all the time. But that is when I suggest that time should be spent doing that. And then once you've served or intend to serve the report, then the guidance comes into play. Next slide, please. So beware the off-the-record instructions. So do be careful about that. I think there are times when you might want to ask your expert about a hypothetical situation, and I have certainly done that off the record. I want to know what their opinion would be if a certain factual matrix was put to them, which may not be part of the other side's case. And the independence of the expert must be maintained, and demonstrably so. And your role as lawyers is to identify the issues, including agreeing a sensible agenda, correcting any misunderstandings of fact and law, and you're advising only really on the form of the report, not the opinion, and obviously keep the expert updated as to the timetable and directions. Next slide. So if you may need to seek substitution, and if you've had reservations about your expert evidence, or they've only just supported your case, then try and flush out those reservations before you need to serve the report. You may not always be able to do so, but at least do it before the first CMC, so you're in a stronger position before the first CMC if you do need to be applying to get a substituted expert, because then the timetabling won't be against you. So if the initial report was more borderline, then it would be more challenging. And you've got to have good reasons. Have they clearly stepped outside their expertise or brief, or otherwise shown themselves to be incompetent? Next slide. So look for evidence of undue influence. Do other cases reveal a pattern with this expert? Don't delay. Proportionality to value will be key, but the fact that the shift is fatal to one side won't be determinative of the application. And don't forget, this is the application of a discretion on the part of the court, so it's difficult to appeal. There we are, changing horses midstream can be very challenging. So thank you very much for your attention. I hope that's been helpful. I think there are some questions that have appeared. So the first question I have is, how do I find a handwriting expert? Gosh. Well, I think they're called graphologists. And I have not, in fact, myself ever dealt with a case with a handwriting expert. I think I'd probably start looking on APIL. Could possibly ask the question of PIBA. I don't know, Kerry, whether you've ever come across
No,
handwriting
I
experts.
haven't.
Lots of Google searches, that the Academy of Experts searching there as well. If anyone else who's online has come across a handwriting expert, can you send us the details? So Veronica, I will have a think about that, and if I can think of any more ideas, I will message you in relation to that. And another question we've been asked is, what is the best way to choose an expert? Well, I think the best way to choose an expert is to, if you're in a firm with people who've got experience of different experts and have actually seen them in action, that's a very good way, because they'll have seen them not only in conference, but at the joint report phase and possibly at trial. Another good thing to do is, if you have an expert who's been recommended to you, do a search on Lawtel, do a search on Westlaw, do a search on Begley to see if they've been in trial and how they've performed. And then obviously look at their CV and their credentials and think about how closely that matches. I would always go for the most detailed CV you can find, look at their published papers, check whether their expertise is really on the subject matter that's in dispute in the case. There's a longer question here, just give me a second to read it, from Imogen. Best course of action to take if a party has failed to seek the court's permission to rely upon an expert's report. Well, if they haven't got permission to rely on it, then they're not going to be able to call them at trial. So I think that's difficult for them. If you've already had a CMC or a CCMC, then I think you can just say to them, we're not going to have any regard to that because you've got no permission to rely on it. And it's a matter for them to do the running and make an application for permission. Hold on one second, I'm just going to look at the second question about that. So when raising questions to experts, it's common for an opponent to object to a question, which is sometimes then not properly answered by the expert, on the basis that they considered to be for clarification of the expert's report. Oh, so is this misusing agendas in circumstances where, in effect, the other party is saying, what I'm really trying to do is clarify your opinion? I think that's to do with the asking of the question. I mean, Part 35 questions are for clarification. I think it depends how important it is, whether it's really proper to sort of fall out about it at that stage. Sometimes I think actually Part 35 questions from the other side can be a great opportunity for your expert to restate their case forcefully and hopefully with clarity. So it's not always a negative thing, because it can give your expert another opportunity, but it will very much depend, I think, on nuance there. So I think your question about the compliance with Part 35 and what one does would be very contingent on how searching the questions are. Certainly cross-examination of experts is to be discouraged through the use of agendas. That's not at all what should be happening. I think I have some more questions. Is everybody happy if I continue to look at those? Yes, we will be sending a copy of the slides out, so that will come out to you as a PDF. And then another very practical and important question: what can you do if your expert double books themselves? Well, the short answer is, and I know people don't like to do this, and I understand why they don't like to do it, but when you book them, summons them. And some of you might groan at that and say that's not very nice and experts don't like it. But I think if you explain to them why you've done it, and you've taken account of their availability dates and whatever clinic and holiday dates and whatever else they've given you, then that's all you can do. Your question is, you booked him first, but the other side now have witness summoned him. Can you claim wasted costs from him? Oh, I've never done that. Well, I suppose if you have tried it, I would look at your terms and conditions quite carefully, and you'd have to study the correspondence to check what the position was. I suspect there's sometimes a difficulty between the lull between getting the date from the court and the communication with the expert. But if all of that tees up, and you can't vacate it because of their absence, or you need to vacate it because of their absence, it wouldn't make you very popular, obviously, with that expert, but they're not helping you and assisting you in the way that they should. And it is part of their duties. So I think I would consider it, but it would depend, again, typical lawyer's answer, it would depend on a very close scrutiny of the correspondence and the dates. And finally, an expert who's subject to an interim review order, their report is not compliant with the terms of the IRO, and her responses to questions are not CPR compliant. What would be the best way to proceed on something like this? Gosh, that doesn't sound like an expert you want to continue instructing. I think it would depend where you are in the litigation as to the steps you might want to take. But I suspect in those circumstances, you might have very good grounds for a substitute expert. I'm just going to answer two more questions that were put before the talk began. And Kerry, people have been listening to my voice for quite a long time now. So do you want to have a go at these two? And then we'll see if we've got enough time to answer more questions. So the two questions we were asked before the talk began, one was, how do you distinguish between an expert advisor and an expert witness?
Yeah, so I'm happy to take that. So the expert witness, as we've already heard, is somebody that has the duty to the court. They provide their evidence to the court. An expert advisor can be used typically, for example, if you're forming your particulars or your defense and you need to know what to be pleaded, you're trying to sound out the strength of your case. If there's maybe some background details where you need information on, you don't necessarily need their evidence to run your case at trial, but you need it to understand your own case and what you want to say. That's when you would use an expert advisor. I don't know if you know any other circumstances, Laura, where one would be useful.
Well, I've actually got a case at the moment where somebody was put forward as either an expert or as a witness, and they had in fact worked for the defendant in the capacity in which we were criticising the defendant. And it became very apparent that they had an axe to grind against the defendant, so they could never have been a suitable expert. But they were very handy for giving me the inside track on how the expert approached these particular tasks and the particular matters in issue. So they were very useful from that standpoint. And I think that there are sometimes cases where, for example, the court's not going to be keen, for example, to give you permission for a pension expert. But having the arithmetic done by somebody who's an IFA might be preferable to counsel, depending on counsel, or you, if you're drafting the schedule. So there are circumstances in which I think it can be helpful to have somebody like that who can either give you an inside track, but they're not totally independent, or they're helping you to marshal some of the evidence with their own expertise, but you're not going to get permission to call them as an expert witness in the case. And the second question we were asked was, when an expert who's already provided a report in the case doesn't want to provide a supplementary report, what can you do? What do you think, Kerry?
Well, first of all, go back to the terms and conditions and say, look, you're really under a duty to provide this. I mean, it depends why they don't want to provide a supplementary report. We were talking just before the start of the webinar, you get a lot of medical experts that are trying to retire, and long ongoing cases pop up and they're like, they don't want to continue. And the starting point normally is, well, they're under a duty, they need to continue. But I've not had any cases where it's been more complicated than that. I don't know about you, Laura. I mean, it would depend, I guess, on the reason why they don't want to provide a supplementary report.
I think there'd have to be a good reason, because when they, you went through before, when you instruct them, their duty is to say whether they can produce the report, and that must include their ability to deal with supplemental issues. I think sometimes experts are trying to retire and trying to stop, and that can be a bit challenging. But if they've agreed instructions in something, relatively recently and produced a report, I can't think of a good reason why they wouldn't be able to deal with an addendum or a supplemental report. And so I think I'd be looking at their T's and C's and sending them copies of the guidance. And also, frankly, if, you know, thinking about if they really are incapable of dealing with an addendum report, do you want them? Is that a good ground for saying, look, there's something gone wrong here with this expert, I might need another one? I think it would very much depend on the facts of the case. Now, I'm conscious that we have been on the line for almost an hour. There are a few more questions. Is everybody happy for me? Well, I tell you what, log off if you don't want to hear any more answers to any questions, and I will do my best to answer the other questions that we still have. So one of the questions is, at what stage is permission granted to rely on an expert? Well, when you do your proposed directions to the court, that is when you normally will set out which expertise or you would want, or which experts you'd want to call, or the subject matter of the expertise that you'd want to call. And then obviously you follow that through at your CMC. So you should be doing it at the stage when you submit your directions to the court and then following it through. And you might change your mind between your draft directions and your CMC. That's not unusual. And you might change your mind having discussed it with your own representatives or your own experts as to which disciplines you want. And then in relation to the expert who'd been subject to the IRO, it's the other side's expert. Well, I think you might be attacking, I mean, it gives you quite a lot of ammunition for cross-examination. So you might actually want to leave that expert in there and then be able to make all the criticisms. If it's so bad that you're able to say that, in fact, they're not an expert, then you would have to make an application to say that the claimant be, or whichever side it is, be debarred from relying on them because they're not an expert. But I think you'd have to take a tactical decision as to whether they're better off left with a shabby expert, frankly, because tactically that might be better for you. But that would be a decision looking at the case in the round. Another question, in a case where one side is looking to instruct their own expert and the other side's requested a single joint expert, is there a preference by the court? I think that will depend on the value of the claim and the complexity of the issues. So the more valuable the claim and the more central the issue is. So for example, I was doing a case the other day, a shoulder dystocia case, where we agreed on a whole raft of experts. There'd been some quite nasty scarring, and we agreed that, in fact, in that case, the scarring probably wasn't going to be that contentious, and we could agree that as a single joint expert, because it wasn't going to be worth a huge amount compared with all of the other issues. So I think it really depends on the value, and also whether there's likely to be a range of opinion and whether that's the central issue in the case. And I'm going to read the last question now. Claimant wants to obtain a report from another expert in the same field because the claimant has made a complaint against the expert. Well, that puts the claimant in some difficulty. It obviously depends on the nature of the breakdown of that relationship, and the onus will be on the claimant if they want to substitute and obtain another expert. You can make them do the running on that, and as you can see from the cases on substitution, it's not easy to do, and that there are some hurdles in the way, but it will very much depend on what happened. Without knowing the substance of the complaint, it's hard to comment any further. Have I reached the end? No, there's another question. To what extent should experts be involved in setting the agenda for their own discussion or joint statement? Is it acceptable for them to see and comment on the draft, or should it just be dealt with by the legal team and first go to them in the final form? So deal with the first bit. To what extent should experts be involved in setting the agenda for their own discussion or joint statement? Well, my rule of thumb is, if you're dealing with a personal injury claim, and these are your quantum experts, and there are no really significant issues on something like, quantum causation, then probably they'll be able to deal with it. I think it really depends on the complexity of the case and the number of issues and whether causation is in fact an issue. So I think it's a question of judgment really for you. I mean, in a clinical negligence case, I would always use agendas, and I think in personal injury claims, for my part, it depends on the complexity and the number and the range of issues. Also, if you've had experts who've made, let me put it this way, pejorative comments or comments where you think you might be borderline applying to redact parts of their reports and things like that, that might encourage you to have an agenda to sort of, narrow the focus in those sorts of cases. So again, I'm sorry, that's a lawyer's answer. It depends, but I've given you my general rule of thumb. I hope that helps. And then the next bit, is it acceptable for them to see and comment on the draft? Do you mean the draft agenda? If you do mean the draft agenda, then I don't think there's any harm in sending a draft agenda to your expert to say, this is what I'm proposing by way of agenda. Is there anything else that you think should be included? You can do that if you want to. I'm not sure how commonly that's done, or you can explore the answers to that. But obviously the agenda just has to deal with whatever is in issue between the parties. So I always go back to the pleaded case to see what's in issue, and then go to the reports to work out what's in issue. And you should be able to come up with a sort of distilled list. I hope that has answered the questions. I don't think there, oh no, there's one more. I'm going to deal with this last one and then I am going to stop. Can an expert report be disclosed to the other side before the court has given permission? Yes, they can. So before proceedings are issued, before permission is granted, you can do what you like with your evidence. It's entirely a matter for you. Very often, parties will engage in without prejudice negotiations, and it's a matter for you whether you elect to serve draft versions of reports. You want to be pretty confident, I think, that that's going to be the final form of the report that the expert is going to produce for you. But it certainly happens very commonly in cases where there might be joint settlement meetings or other negotiations before claims have been issued. So I hope that's been helpful. If any of you do have questions, don't hesitate to email Kerry or I. And as we say, you'll get copies of the talk as a PDF document after today. And I hope it's been helpful, as I say. Okay, thank you very much, everybody.
Thanks, everybody. Bye.
Bye-bye.